Hello. Hello. Good afternoon. I hope everybody's had a chance to get settled in and get some lunch. We're very excited to go ahead and start the program. I am Kelly Voss. I am president of the Washington Council of Lawyers. And on behalf of the council, I just want to thank you all for being here today. Thank our panelists. We're very excited about the program. I'm personally very excited to sort of hear about the Supreme Court's recent term and the road ahead. Before we begin the program, I wanted to take a moment to express appreciation for some of the folks who made the program possible today. First and foremost, I want to thank Arnold and Porter, Kay Scholler. It's very generous to donate the space. Arnold and Porter has long been a supporter of the Washington Council's work, and I really appreciate it, so thank you. We also have several co-sponsoring organizations that I want to acknowledge. They are the DC Lawyer, chapter of the American Constitution Society, the Bar Association of DC, the Capitol Hill Area chapter of the Federal Bar Association, the Capitol Area Muslim Bar Association, the DC Association of Criminal Defense Lawyers, the Greater Washington Area Chapter Women Lawyers Division of the National Bar Association, GWAC. And I also want to give a special thank you to the individuals who really played an instrumental role in planning the panel today and making it possible. And those are Marcia Tucker, Fritz Mulhauser, who's somewhere out in the crowd, and Arthur Spitzer. So thank you guys. So before we begin the program, I just also want to take a minute to tell you a little bit about the Washington Council of Lawyers. We are the DC Public Interest Bar Association. So we are the bar association in DC that's really devoted to advancing access to justice, public interest, and pro bono practice. So by being a WCL supporter and member, you're really getting access to great events like this, but also being part of that broader community of lawyers of all stripes from all sectors who are really interested in using their professional skills to help others. I hope that, on your way out, you'll visit our website or stop by. We'd be happy to help you get signed up and consider joining to be a member of WCL if you're not already. To give you a glimpse of what WCL offers, we've got some information on the tables as well, but I'll just run through some of the events that we've got coming up through the summer. On July 11th, you can sign up to have lunch with former DC Superior Chief Judge Eric Washington. Space is limited on that. We've only got 10 seats left, so if you want to attend, please do go ahead and sign up today if you're able. On July 19th, we have our monthly happy hour. This is just a great chance to informally catch up with WCL friends, meet new friends, and so on. On August 12th, we have a community service pro bono opportunity. You can sign up to help us staff the DC Bar Pro Bono Center's Advice and Referral Clinic. It's a really wonderful way to spend a Saturday. You're helping people in the community that need legal advice and doing so alongside lawyers that are interesting to meet. Finally, on July 24th, we're hosting our annual summer forum for pro bono and public interest practice. We're really excited. Justice Ginsburg is going to be our keynote speaker, so we're really thrilled to be able to hear from her about the importance of pro bono and public interest work. It is sold out, so that's the bad news, but I do hope that we'll see some of you there, that you're able to get tickets, and if you're, have a ticket and aren't able to attend, consider passing it to a friend because it is a sold-out event. You can find information about all of our events on the website. You can also follow us on Twitter. I'm not on Twitter, but we are. It's at Wash Lawyers. I think somebody's live tweeting the event today, so please do be sure to catch that as well. I will turn this over now to Arthur Spitzer, the legal director at the ACLU of the District of Columbia, who'll be moderating today.
Thank you. I'm standing temporarily just so I can see who is where on this long table. You've got short biographical sketches of the speakers in your program, but for the benefit of those who may be watching the videotape and not have the program, I'm going to make short introductions. In order of how long they've been covering the court, Tony Mauro, who is second from the end on the right, has been covering the court since 1979, first for Gannett and USA Today, and most recently for the National Law Journal and other American lawyer media publications. He's written 3 books about the court, and got his MS in journalism from Columbia University Graduate School of Journalism. David Savage, who is at the far right, has been covering the court for the Los Angeles Times and also the Chicago Tribune since 1986. He's authored the latest edition of the Guide to the United States Supreme Court, published by CQ Press. Joan Biskupic, who's proud in the middle, is the editor-in-charge for legal affairs at Reuters. She's been covering the court since 1989 and has published biographies of 3 of the justices, Antonin Scalia, Sandra Day O'Connor, and Sonia Sotomayor, and is now working on her next book, which we will ask her about during the program. She has a law degree from Georgetown, and she spent this past year as a visiting law professor at the University of California, Irvine. Robert Barnes, who is two from me, on Joan's left, is the Supreme Court reporter for the Washington Post. He's been at the Post since 1987. He was a political editor, metropolitan editor, has been covering the court since 2006. Bob had been planning to go to law school, but changed his mind after taking a journalism course as an undergraduate. His biography at WashingtonPost.com says, or at least used to say, I didn't look again, says it didn't occur to him, as it apparently did to others, that he could do both. But he managed to avoid 3 years of law school and still got to cover the court. Adam Liptak, next to me, took over the New York Times Supreme Court beat 9 years ago, but he has a long history with the Times, which he first joined as a copy boy in 1984 and returned with a law degree in 1988, where he worked in the in-house Times legal department for a number of years. About a decade later, he became a reporter covering legal issues and then covering the Supreme Court. Amy Howe, thank you for raising your hand, is currently a reporter and independent contractor at SCOTUSblog, but until recently was its editor. Before turning to full-time blogging and internet coverage, she served as counsel on more than 24 merits cases at the court and argued 2 cases there, and has also taught Supreme Court litigation at Stanford and at Harvard. Amy's a graduate of UNC Chapel Hill and holds a master's in Arab studies, as well as a law degree from Georgetown. Ariane de Vogue, who can raise her hand, the one hand she can raise, with the other one broken, is a reporter and producer for CNN, covering the court and other legal issues and guiding its network-wide reporting on Supreme Court cases and legal developments. Before joining CNN in 2015, she covered the court and several Supreme Court nominations for ABC News, and before that was an investigative reporter. I like the fact that she grew up in Westville, Indiana, population 5,959, which is 103 more than it was a year ago, and is also a graduate of George Washington University. So I'm now going to sit down, and we'll begin the panel. Mic on, thank you. Except for Amy, this is not a panel of litigators. We'll talk about cases somewhat, but really we want to talk about the court and how journalists cover the court. We plan to save some time for questions at the end, so you can think about what you might want to ask so that we don't have empty silence at 10 of 2 when I ask for questions. So the Supreme Court term ended, for all practical purposes, on Monday, and it was a very complicated day. There were opinions in 3 argued cases, all of them with dissents. There was action in the travel ban case with a per curiam opinion and a separate opinion. There were 3 other per curiam opinions with dissents, including several that were closely watched and some that involved high-profile issues. Many of those things would have been front-page news in an ordinary week, and of course everyone wants to know about all of them right away. So how can a journalist manage to deal with that much stuff at 10:30 in the morning and satisfy your editors and your audiences? I'll start with Ariane, because you're on TV. Do you just get in front of a camera and start talking and keep talking for an hour?
No. Does this work?
You have to push the button.
Yep. All right. Well, so on the last day of the term, I actually wasn't on television because we have a whole team of people, and I do it on more quiet days. But on the last day of the term, we bring in the big guns, and I was sitting in the press room. And I think one of my biggest regrets covering the court is I have never been out on the plaza on the big days, nor have I been in the courtroom. I sit in my tiny little cubicle and race through opinions and orders and more and more and more, and I never get to see the great drama that all of you see. So on how CNN does it, at least, is this time we had Joan, who is also a CNN analyst, and she was up in the courtroom, and we had our correspondent, Jess Snyder, outside with a legal expert. I was inside getting it. We get on a conference call, and we go through it as quickly as we can, starting with the orders on that last day. And I was surprised, maybe everybody else here knew, but I was surprised to get the travel ban. I didn't expect that to come down in the way it did on an opinion day. I thought it would come down as an order or Tuesday. So we rifle through it, and that was the last thing that they handed to us, and that was a real surprise. And I think you have to think fast when when something like that happens. So that's how we do it at CNN. I don't know how everybody else does.
Well, it always is a busy day, and so you have a good idea of what's coming down. This term, it was a little bit different in that we thought that there would be a few cases that would end in a tie and thus be set for re-argument so that Justice Gorsuch could be part of that. There ended up being two of them. So usually you know everything that's going to come down the last day. This one we didn't. And the travel ban was a surprise there at the end. We thought that we would either get it a little earlier in the day or not get it that day. And, you know, we have all of us write a lot of stuff in advance. I had 3 versions of the travel ban story ready, none of which turned out to be accurate because the court did something that neither side asked for. And so you have to move kind of quickly on those. My editors always want to hear from me before they put anything up on the web. And so, you know, I try to give them as quick as I can a reading and say, you know, sometimes you can say this, but I don't think you can say this yet, or this part next. Sometimes it will turn out that we can do it, but you've got to make one sort of quick pass at it and then read more deeply into what it says. But, you know, it's just the way it is on the last day, and we were talking that it's a little unfortunate that the court leaves so much for the last day because there are always something that you would have liked to have spent more time on or written about more comprehensively that just gets lost by the wayside.
It's easy for me to figure out what 2 of your advanced stories on the travel ban were, right? Stay denied, stay granted. What was your third advanced story?
Well, I don't know. We had figured out there were like 4 or 5 ways that you could do it, right? You could grant but not stay. You know, you could. There were a number of configurations. They're all in my file, if you want me to call them. They haven't killed out yet.
So, Amy, in addition to posting stories on SCOTUSblog about what the court decided, you also host a live blog starting at 9 o'clock or 9:15 in the morning on days when there'll be orders and decisions. So you're actually live before any of the other people at the story. How does that work? One thing probably everyone here who's been to the Supreme Court knows is no electronic devices are allowed in the courtroom. They even make me take my Apple Watch off now before I can go in because they think I can do something nefarious with it. And maybe I can, but I don't know how. And so you're obviously not in the courtroom with a laptop.
Right. No, I'm down in the press room with the other reporters, and it's sort of business as usual until about 3 or 4 minutes before the court is ready to issue the opinions. And there's a 5-minute buzzer that goes off 5 minutes before the justices are set to take the bench. And until then, the live blog is something that we started in no small part to sort of ease the burden on our servers so that people weren't hitting refresh over and over again and crashing the servers. But one thing that it does is it allows us to interact with our readers in a way that we're not normally able to. And it's something that is one of my favorite parts of the day. And so I'm usually on there answering questions, talking about what cases might be decided that day. And it's certainly something that's easy to do on the last day of the term, sort of sussing out all of the possibilities. And then a couple of minutes before the court is set to issue opinions, I go into the public information office itself, which is adjacent to the press room with the other reporters. And there's sort of a pecking order in terms of waiting to get your copy of the opinion, because the AP guys and the folks on the wires get first access to the opinions so that they can get back and get on the phone to their editors as soon as possible. And so we hear over an intercom from the courtroom, the second that the marshal gavels the session to an open, the Chief Justice, the Associate Justices, and then the Chief Justice comes on and says, Justice Kagan has our opinion in Perry versus Merit Systems Protection Board, and she reads a summary of the opinion. And at that point, the PIO starts handing out copies of the opinions, and we grab them and we run back to the press room, and I'll start typing to try and sort of let our readers know sort of the basics of what's going on. But then with one ear, you're also listening to what's going on in the PIO, because sometimes the justices will read lengthy summaries of their decisions. Sometimes there will be a dissent, as there was this week, read from the bench. But sometimes some justices will read very quick opinions, as Justice Alito did last week, or even a sort of one-sentence summary of his holding, and then you've got to rush back in to get the next opinion. And Monday was particularly hectic, not only because we weren't really expecting the court to act on the travel ban from the bench, but because, as I think we're going to discuss later, there were also rumors about Justice Kennedy retiring. So even after they issued the opinion in the travel ban, you still had to go back into the PIO to listen to see whether there was going to be anything announced from the bench about a retirement. And there were retirements. There was a couple of longtime court employees who had retired, and then the Chief Justice paid a lovely tribute to Lyle Denniston. But there was not a retirement by Justice Kennedy.
David, how many advanced stories had you written about the travel ban? Yeah. Same.
And none of them were correct, of course. May I ask this group a question? All of you, if you read about Supreme Court news this week, what was designed, did you do it immediately, like within on a phone or something online, or did you read it sometime later in the next 24 hours? Do you recall? I mean, in other words, do most of you get your news immediately? Media?
Hands up for those who went online, by 11 o'clock to see the news.
Okay. I was talking to a group of school teachers last week, and I was trying to explain how this works. And I was telling about how we just race because of the sense of the web. It's really changed how everything is done, and everybody races. Almost literally, they were running across the room to file something immediately. And these teachers are looking at me. I thought, no, wait, these people have lives. They're not sitting around. So it does occur to me that we are so driven by the speed and the time. That's why we have the 3 different versions of the story, because you want to say, rather than doing what I think I should do, which is get the travel ban order, read it, figure out what it means, because they found a sort of a compromise way, and then go write it. The view now is, well, that takes too damn long. We've got I had in effect a Trump wins, Trump loses, and something in between, but none of it worked. And so I put up one of it, and then I changed it and all that. And I'm just struck by the fact that how we are all racing because of the pressure of the web. I don't know whether it's right or wrong, but there's this great sense that you've got to have something very, very fast. And it puts a real premium on trying to, quickly make a decision about what something says. I thought the Missouri case on the church was also a little bit of a problem, because, the real question in that case is whether they were going to decide it broadly as a religious right sort of for public funding, or decide it as a case about school playgrounds. And John Roberts has this opinion, says, I speak for the court except for footnote 3, which is about that. And then it turns out some of the justices agreed with the footnote and some didn't. And so even learning how to write the right first sentence, you've got to figure out, well, okay, who was on that footnote and who not. So anyway, I'm just surprised that there's such a great pressure to get things out fast, and it really makes it hard when there's a little bit of a close call as to what they actually decided.
So Adam, I heard you recently talk about how Linda Greenhouse used to cover Supreme Court decision days, and maybe it would be fun for you to remind us about that again.
So I started covering the court in 2008, not that long ago. I succeeded the great Linda Greenhouse, who covered the court with great distinction for 30 years. When she left, and again, this is less than a decade ago, she didn't have a computer at the courthouse. She wouldn't write for the web. She would read the decision from start to finish. She would consult with experts. She would have a sandwich. For all I know, she would take a nap. And then in the late afternoon, she'd produce a really good story. And that's just a reflection of how much things have changed. Everything you've heard so far is true of me, too. There are two pernicious things happening at the same time. One, the court decides to do everything simultaneously. Two, you have to write about it immediately. And that means, when I started on the beat, I said, well, I'll tell you one thing. I'm never going to write about a decision until I've read it. Well, that's out the window. And now I put up this pre-written stuff that just tells you what the bottom line was. That gets an enormous readership. In the course of the day, as we all do, we make it better. And at the end of the day, I hope that, the people who still read the print product on the Upper West Side of Manhattan, get a pretty good story. But there's a completely inverse relationship between quality of product and readership. So readers get immediate access to a bare bones story. And then the value, and we're capable of adding some value. I mean, we cover the court. We have some sense of context and consequences and doctrine. And we build that into the story, but I fear that the readership for that story later in the day or the next morning is quite small.
Amy, you mentioned that the Chief Justice gave a tribute to Lyle Denniston on his reporting. For those of you long-timers, has that ever happened before? Have they ever recognized a reporter from the bench? Tony, you're our longest timer.
As far as I know, it's never happened. As was mentioned, the Chief Justice will take note of a retirement, and usually he says retirement, and everybody starts gasping like, oh my God, and it turns out to be the reporter of decisions or something. I think he likes that suspense. But they're usually they're court employees, so this was very unusual. But Lyle is very unusual. He's been covering the court since 1958 or something like that, and it's just an institution very well known and well liked and loved at the court. So I think it was fitting, and I don't think the rest of us. I should speak for myself. I don't think I'll get that kind of reception.
I think I figured out that I'd have to cover the court till I was 99 to catch up with Lyle, so I don't think I'm getting it either.
I was in the courtroom, and it was a nice moment because Lyle's wife, Pamela, who happens to be a lawyer herself, was sitting in the first seat in the bar section, and Lyle was in there, and there were a handful of us who were lucky enough to not have to scramble to be up there and watch the whole atmosphere. He didn't know exactly what was coming, and of course, the look on his face reflected his appreciation. But the other thing that was notable was that all the other justices, across ideological lines, across all sorts of temperaments, all seemed to get into it too. So it was a beautiful moment in the courtroom. And there were several people who had come that morning, spouses of the justices and spouses of the full-time court staff, including the PIO, that when I saw them in the room, I thought, uh-oh, maybe something is happening. But it was for Lyle and to celebrate the last day.
Now, all the justices were looking towards the press gallery with big smiles on their faces, which I've never seen before. They don't usually look in there.
I would like all of us to leave.
So let me go back for a little bit to the travel ban. There are some obvious questions, and I was wondering if any of you had time to do some reporting on them. And actually, I got some answer to that question from this morning's papers because there was some reporting on it. The per curiam opinion said we've drawn a line that we think will be easy to administer. And Justice Thomas's separate opinion said you've drawn a completely unworkable line, and there's going to be tons of litigation in the next few months. What have you guys been able to find out about that just in the last couple of days?
Well, I think we're going to figure out much more tomorrow, Thursday, when we think there'll probably be a rollout. But I thought that what was one interesting thing about it is if you looked at that opinion, the per curiam was very nuts and bolts. Sort of, this is what happened and this is what we're going to do. And I thought it was pretty clear, whoever wrote it, which I think Roberts wrote it, it's pretty clear what they were going to do. So that part wasn't hard. But I was struck by the dissent, and I was struck by the language of Thomas and Gorsuch and Alito saying, you are going to flood this place with litigation, and this is a compromise. So I thought it was interesting because the per curiam opinion clearly wanted to sort of bring down the temperature from some of the lower court opinions and just sort of lay out what had happened and what's going to happen now. But I thought there was a little bit more sort of oomph in that dissent. And I was surprised that some people didn't think that or didn't pick that up. I was surprised by that a bit.
Looks like someone else that was eager to say something. No. Well, another thing that the court did in its order was it directed the parties to brief the question of whether the case had actually become moot a week ago or so. And I wonder if you've had time to do reporting on that. And isn't it curious, or at least it is to me, that the court didn't ask them to brief that in advance, perhaps, rather than do full-scale briefs and full-scale argument, only then to decide if the case had already been moot before they granted cert?
I mean, I think they had already, the case was already moving so quickly. The last set of filings came in the day before last Thursday's conference, and so there really might just not have been time to add an extra layer of briefing. But Marty Lederman has a post at Just Security today that I thought was pretty insightful. He said that the only way that they could act on the stays was to act on the petitions, putting aside the mootness question, because the government had asked the court to grant the stays pending the appeal. So if they deny cert because they think the case is going to moot out, that the stays.
Yeah, I was going to add to that is that the rhetoric of the court was certainly responding exactly to the administration along the lines that Amy just said, but also to say, look at what you've asked us to do. You haven't asked us to expedite any part of this more than we are doing, which underscored the idea that publicly the Trump administration might be saying, you have to act urgently, you have to act urgently. But the fact was that the Trump administration lawyers had said that this kind of briefing schedule would work. And I think that we could end up, this could be the high water mark for the litigation. No, we're going to definitely have other kind of litigation over just who is covered by the bona fide relationship issue, I'm sure. But in terms of the Supreme Court ever deciding the merits of this, it's a pretty good, odds are we might not ever see that kind of ruling because it will all go away by the fall.
Well, I just wanted to mention one other just side issue that has arisen, the question of whether Justice Ginsburg should recuse in the travel ban cases. It goes back to, you'll recall last summer, Justice Ginsburg gave several interviews and to folks here and others, and she was very disparaging about Donald Trump. Called him a faker, said, suggested maybe we should move to New Zealand if he's elected, that kind of thing. And so a group of Republican members of the House have written her a letter, I think yesterday or the day before, demanding that she recuse because of the federal recusal statute that says that appearance of bias, appearance of impartiality, is cause for recusal. I just did a story about it, and most judicial ethics experts I talked to said it's really unlikely and is not necessary. The theory being that if Ginsburg had to recuse for this case, would she have to recuse in every case that is brought by the Trump administration? But I think it's still going to be interesting to see how Justice Ginsburg responds to it.
I will take any bet from anyone on this table saying that she will recuse. I'll say she won't. So, Adam, I think it was initially your interview with her where she talked about moving to New Zealand, and then Joan, I think you interviewed her a couple of days later where she talked about Trump being a faker. How far did your jaws drop when she said those things to you?
The sequence was Mark Sherman of the Associated Press went to see her, and she said something along those lines, although in milder terms. And then a day or two later, I went up to see her, and then a day or two after that, I think Joan did. But Mark, having opened the door to the possibility that she would comment on a presidential candidate, didn't. So I wasn't shocked that she would do that as a category of statement. But it got more colorful as it went along. And as a journalist, I'm all for that.
Well, it's funny. A couple people said to me, in fact, a former Supreme Court journalist said to me, wouldn't you have wanted to protect Justice Ginsburg when she said that kind of thing? And I said, no. In fact, by the time I got in there, and I thought I gave her a chance to walk the quotes back because Adam and Mark had gone in before the weekend, and so the stories had run over the weekend and then in that Sunday and Monday paper. So I saw her Monday late afternoon, and I was in there interviewing her on my John Roberts book, but I thought I'm not going to look up story in the mouth. I'm going to, if there's some story here that I can write up, I'll take it. And I said, you've gotten some criticism for what you had commented on regarding Donald Trump, and if he wins, you'll move to New Zealand. Do you regret saying it? And she said, no. And I said, really? Elaborate more. And that's when she said, he's a faker. He should release his income tax. And I thought, well, she knew what criticism was out there, and she still seized on it. I think by the time we got to midweek, when Trump then was tweeting what he said, that she should go, and there was a New York Times editorial about how she had perhaps crossed the line. And then if you recall, I think it was by Thursday, right before the Republican convention, where she said, all right, I regret saying it, but P.S. I don't regret the sentiment. But anyway, it wasn't as much as that. But I don't think we will see Ruth Bader Ginsburg commenting on politics for a while now. Yeah.
I can tell you that by the time I got back from my family reunion, she wasn't taking any more interview requests.
So aside from the end of term events we've been talking about, I suppose the biggest story about the court this year overall was the unsuccessful nomination of Merrick Garland and then the successful confirmation of Neil Gorsuch and the operation of the court from October through March with 8 justices. Adam, you wrote a piece earlier this spring saying the Supreme Court beat is usually gloriously predictable, but this past year was a 4-alarm journalistic fire. How so?
Well, I mean, it's a great beat because the court will give you their schedule like into 2019, and you know which days you have to work, and you know that at the end of the term you have to work pretty hard. But I'm pretty much open till October now. And things happen, in a predictable way, which is great. But Justice Scalia's death in February of 2016 completely threw all of this kind of this one aspect of the beat into free fall. And then we had the first nomination and what was going to happen with that, and Gorsuch. And it also moved the center of gravity of covering the court away from my preference, which is cases and law, into politics and filibuster procedure, about which to this day I know nothing. So it made it harder, less predictable. You have speaking engagements you have to cancel. It's a pain in the neck.
Do you think that the people at this table, cover these nomination stories differently from the way your colleagues who aren't used to covering the court do? Are you more oriented to the legal backgrounds of the nominees, for example, and less to the politics, Joan?
Well, I would hope so. I think what all of us bring to it is that we know what the cases are about. We know where the court has been in a particular area of the law, so that when a nominee says something, we can illuminate, first of all, the subject area, and then also try to bring some context to it based on what other nominees have said in the past and where the court might be going. Each year each nomination, of course, it gets more and more opaque and difficult to say exactly what the nominee believes. I think this time around, Neil Gorsuch certainly wanted to make sure that whatever his beliefs were not revealed. I mean, the whole point of being up there is to get confirmed, not to try to make it a seminar in the law, as used to be the case. So it's good for all of us, because then we can test what a nominee says with his or her record. And Neil Gorsuch has already really revealed himself in just these couple months.
Why don't you elaborate on that a bit?
Well, look at, I'll pick up first on what Ariane said about the vote in the travel ban case. He aligned himself there with Justices Thomas and Alito, and he aligned himself with Justices Thomas and Alito in several cases on the far right side. He certainly has launched in there, not in any kind of tentative way, but to say, I have very strong conservative views that would indeed match the late Justice Scalia, and maybe in some cases go further to the right than Justice Scalia. There was this one interesting, he's also been quite assertive on the bench during oral arguments, and there was one case just that he and the chief got into it a little bit, and I only picked up on it because I was in California. I was listening to all the oral arguments through the audio at the end of the week, and there was one kind of B-grade case where there was some discussion over I-80 or I-90, transportation there, and I could hear rustling around, and I wondered what that was all about. Well, Justice Gorsuch had corrected the chief on exactly what interstate was going through Wyoming or Montana, and people were rustling around looking for atlases during it. And what happened was Neil Gorsuch had to then correct himself to say, I was wrong when I corrected the Chief Justice. So he's mixing it up both on paper with these rulings in a big way, and then, as I say, also on the bench.
So on the first oral argument, the junior-most justice usually starts pretty quietly, more or less. And I remember when we went for the first week at the end of April, and I think it was his first argument, and he launches right into a question, and then another one, and then another one, and then at one point he said, well, I'm sorry to take up so much time. That was very interesting. I mean, right out of the gate, he was adding to the bench in a way that I thought was a little surprising. I mean, he's come out of the gate roaring in so many ways.
Yeah, I did a piece about this today too, and there was one interesting thing in the orders from the last day, a case that no one had paid much attention to. It was an order that, and the Chief Justice and Justice Thomas had dissented from what the court did, and Gorsuch wrote a concurrence, which seemed very sort of out of order for an order like that. And a couple of people that I talked to yesterday about this said that they were very surprised to see it, and they sort of wonder about the dynamics that are going on there if he had decided to, sort of confront the Chief Justice publicly over something that didn't seem terribly consequential.
Yeah, for those who don't know what Bob's talking about, it was a GVR, a grant, vacate, and remand, in a case about an error in criminal sentencing. And the Solicitor General had confessed that the trial judge had made a mistake in sentencing this defendant, and the court agreed to vacate the ruling below and send it back for the judge to fix it. It seems quite routine. And yet the chief dissented, and Gorsuch wrote an opinion explaining why he agreed with the court's decision to do what it did. Amy, I see your hand is up.
Yeah, I mean, I think I've been sort of following the court and covering the court long enough that it seems like every time we get a new justice, I remember hearing someone telling me the complaints about from Justice Blackmun that Justice Ginsburg was talking too much in oral argument, and then again with Justice Sotomayor that she was talking too much. And you don't get to the Supreme Court by being a shrinking violet, but I do think that these separate opinions are really sort of interesting. The one plausible explanation is he didn't really have anything else to do, because he'd written his one opinion for April, and gee, let's have some fun. But then I went back and looked at the court archives, the opinions relating to orders going back to 2011, and Justice Elena Kagan has written one separate opinion, or at least been the author, and that covers all of the terms that she's been on the bench except for her first term on the bench. And so I do think that's kind of a statement, like, I'm here to shake things up, whereas I think she came on the court as sort of, I'm going to be a bridge builder, and she's only dissented from the bench once in her 7 years on the bench. She's never written a solo dissent. So I do think that's a very different approach.
Just a footnote on, I think it also is a function of the clerks, his law clerks needing something to do. Some of Gorsuch's clerks are there have been there only from April through July or August, and so I think they want some work product they can.
And they're very experienced too.
Yeah.
Right.
Oh, I suppose if people are complaining that he's asking too many questions, that's a good thing, that they're not complaining that some female justice is asking too many questions.
Exactly, yes.
Let me go back for just a moment to the nomination process. Has anyone spoken with Merrick Garland since January 20th? Does anyone have any clue about how he looks back on this whole episode? Is that a story you might want to write if you haven't already? Silence. Bob?
Well, I think the Times did do a story about it, but he has not given any interviews. And I know that he's been asked many times to give interviews about it, and he has not. He's gone back to work on the bench, and he was always someone who showed up for lots of events, and he still does that. You see him all the time now at various legal events, but he has not given any interviews about that experience.
So it must have been terribly painful and disappointing to him, but I think everyone agrees on all sides of the aisle that he handled it with exceptional grace and grit.
Have any of you had a chance yet to speak with Justice Gorsuch?
I have not, but I know that some reporters in the press room are thinking that maybe they could time their afternoon runs to try and run into Justice Gorsuch.
Well, I had that experience, Art. I go running on Sunday down from Thompson's Boathouse down near the Watergate. One morning I was down there about 8 o'clock, and I was warming up waiting for a friend, and there's one guy standing on the dock, and I said, geez, that looks a lot like Neil Gorsuch. So I walked over, and it was Gorsuch, so I talked to him for a few minutes, and he said to me, so David, you're a scholar? And I thought, gee, nobody's ever called me a scholar, but... And then I realized he was taking one of these scull boats out. He was standing, he was waiting for somebody to... So I saw him yesterday, and he said, oh, you're the runner. So anyway, that's my entire encounter with Neil Gorsuch.
So now we know that he's a scholar?
Yes.
Yes. A scholar and a scholar, that's right. That's right. So the court operated from October, actually from much earlier than that, but this term from October through March with 8 justices. How did that affect the operation of the court? Was it a big deal or not so much? Adam?
It was a tiny, boring docket, and in order to avoid 4-4 ties, the court worked awfully hard to find consensus, meaning they would issue decisions that were so narrow you couldn't really tell what they were doing. Not infrequently, they would identify a legal standard that was indistinguishable from the one the court below had applied and sent it back to the lower court to apply the new indistinguishable standard.
Well, I have to say that it made my job harder because when you are thinking how the court is going to rule and you have to think about it ahead of time because you get it so quickly, I do think that you had to take on this whole new thought process now. Well, how could the court rule if it's going to do something narrow? And that's tough because you sort of it makes you think a lot harder about what could come out. And I remember I got stuck with the contraceptive mandate case, walking out with it in my hand, heading toward the cameras, and someone saying, well, who wins? Who loses? And it was tough because that was one of those cases that came down and you're like, wait, what? What did they do? Because you have to think about things differently. So for me, the 404s added a burden. And I also thought in my head, did it make their conferences more interesting? I mean, did it change it when they were sitting around the room and saying, okay, now we really got to talk this out? And I'd like to think that like Justice Breyer might have thought, all right, let's talk about this. And some other justices might have been like, so I think that's an interesting dynamic.
Yeah, I thought there was something interesting too with there were 3 cases that the court accepted before Justice Scalia died in January of 2016. It took forever to get those cases onto the oral argument schedule. And it seemed clear that that was because they thought perhaps they would be controversial. Trinity Lutheran was one of those. And so everyone thought maybe that's a 4-4. That's why it's taking so long. They didn't schedule it until April when Justice Gorsuch had got on the court. But then in oral argument, almost immediately it became clear to those listening that it probably wasn't going to be a 4-4 case, that they had sort of thought that there was a narrower way to do this, and you could see it in the arguments that it would likely be a 7-2 case, which is what it turned out to be. And so it was interesting to me because you always hear the justices say, we never discussed the case before oral argument. I'm not sure I ever quite believed that, but maybe it's actually true.
Joan, even before Justice Gorsuch was confirmed, you wrote a piece called Gorsuch and Roberts, a relationship that could define American justice. And you said, if the Senate confirms Gorsuch, a looming question is whether these 2 polished jurists would find common ground or end up as rivals on the right. Do you think you know the answer to that already?
Yes, I think at least in this first term, he's not aligning with the chief in key ways. In that story, I liken the 2. They both had gone to prep schools. They both are products of the Ivy League schools. They both present, obviously, a very polished demeanor and had worked in Republican administrations. And I was curious how they would maneuver with each other and if Neil Gorsuch would be a natural ally to the chief in some ways that Justice Kennedy has been as they broker some of the compromises that we've talked about up here when the court is shorthanded or has a particularly tough decision. But he has already staked out his ground in a couple different ways. You heard us talk about what happens at oral arguments. You heard us talk about some of the concurrences and dissents that he's been part of. But in another way, he did not join the so-called cert pool, which set him aside in a different manner. That's the process by which the justices screen all the petitions that come in. Most of them have their law clerks join a pool where they do collective screening. Justice Alito is not part of that. Before him, Justice John Paul Stevens was not part of it. But most of the new justices over time have decided, I'll come in, I'll join, I'll let my clerks do this, I'll be part of the group screening, and then I'll decide whether I'm missing something and I want to break away. But he right from the start said, I'm not going to be part of that, I'm going to set myself up in a different way, which I thought was again a statement that I'm going to try to be my own kind of person here, and I think that sent a pretty loud signal again early on.
Bob, you wrote a little bit about the same subject in this morning's paper. Do you feel basically the same way Joan does about it?
Yeah, I think it's been interesting to see that he, even if he has joined the judgment of the court in something, that he has gone his own way. He most often is with Justice Thomas when he does that, sometimes with Justice Alito. He has carried the textualist thing that you heard so much about at the nomination, certainly through his first round of arguments. He beats that drum very hard. I can't remember if it was a dissent or concurrence. I guess it was a dissent to Justice Ginsburg reading where he said that she tweaked the law in order to come out with an outcome that everyone agreed worked a little better, and that there's a way to fix the law, and it's called legislation. And it was very tough and very textualist, but no one agreed with him except Justice Thomas, not even Justice Alito or the Chief. And so, again, it shows that not only is he willing to go out on his own, but he is apart from them.
There was even a case that I'm still trying to make sense of where he joins the majority opinion in full, and then he joins a concurrence, which is fine because the concurrence is on board for the rationale, just wants to say something more. And then he also joins a concurrence in the judgment, which rejects the rationale of the majority opinion. But so he's an interesting, flexible fellow.
I agree with all that's been said about Gorsuch. I thought the 2 points that you sort of end this term on the travel ban, they find a sort of pragmatic middle ground approach that diffuses the controversy. And to me, that's classic John Roberts. They didn't want to go too far one way or too far the other way. They didn't want to endorse what all these judges are doing and sort of striking down the travel ban entirely. They didn't want to go the other way and allow it to go into force just like that. So they found a sort of a pragmatic middle ground, which Roberts is a cautious guy and really likes that. I've found a story that I don't know whether it's run yet, but basically saying Gorsuch is a conservative activist. There's a whole series of areas right away on guns, gay rights, on campaign finance, where particularly religion and religious liberty, that he wants to, and he's very clear, very direct about this, he wants to move the law to the right. He's not there as a sort of cautious guy to uphold precedent and uphold laws. They're going to move the law to the right if he can do it. And this decision on the Missouri school, he wasn't going to go along with that footnote. He thinks any discrimination in funding, like there's a vouchers case in Colorado, that this is discrimination based on religion and it's unconstitutional. And so I think the really interesting thing going ahead is that he's going to be a very smart advocate pushing to the right in a sort of aggressive way. I think that's what we've seen.
So a few minutes ago, Ariane, you spoke about coming out with an opinion in your hand, and people wanted to know who won, who lost. I wonder how people deal with an opinion like this one, which happens usually several times a year. This was Ziegler against Abbasi on June 19th. It's 68 pages long, and the paragraph at the end of the syllabus says, Kennedy J. delivered the opinion of the court with respect to parts 1, 2, 3, 4A, and 5, in which Roberts, CJ, and Thomas and Alito joined, and an opinion with respect to Part 4B, in which Roberts and Alito joined. Thomas filed an opinion concurring in part and concurring in the judgment. Breyer filed a dissenting opinion in which Ginsburg joined. Sotomayor, Kagan, and Gorsuch took no part. So when someone's saying to you, who won, who lost, what did they say? How long does it take you to answer that question, and how many minutes before that do you need to be filing a story?
That's when you want to break into tears when you see something like that, because and what that brings back to me is the affirmative action case when they basically punted and
The first Fisher?
yeah,
Yeah.
and you get that and you say, did they just punt? And you're on deadline. And ever since that opinion came down, that's when I really go back to, okay, what are all the possible ways they can rule? Because when you read something like that, maybe not my esteemed colleagues here, but when I read something like that, I already get really nervous on deadline. That's tough to see.
And this was one, I think, I remember reading this and trying to figure out what to do with it for the live blog, and I would just type, it's complicated. And I actually put off doing my story. It was probably the lead story of the day, but I made it like the second or third story that I did because I just didn't want to face it. And as I recall, like once you actually have the time to look at it, it wasn't that complicated.
I mean, you can fairly quickly figure out the Ashcroft and Mueller one.
Because I remember finally reading through it and being like, oh, yeah, this is fine.
There's some nonsense about the warden, but Ashcroft,
right.
Mueller, and Ziegler all won.
But do you remember at the end of one term when Rehnquist was ill? And we were waiting, wondering if he was going to announce a retirement. And I remember at that time we were in a trailer because the press room was being worked on. And Rehnquist had great difficulty in talking. He was extremely brave. And he read through one of those. And at the end, you're just rolling your eyes. And then he said, I didn't know we had that many members on this court. And he was so ill. And it was so funny that he had the same reaction that some of us had.
Just one thing that I do when I see an array of opinions like that is I head for the dissent, because sometimes the dissenters will sort of distill what it is they're angry about in a way that sort of makes you able to jump back to the split majority and sort of figure things out. It doesn't always work, but sometimes the dissent. Very often I'll read the dissent first.
You also kind of know from that case going in, it was a 6-justice court. Gorsuch was out because he hadn't heard it argued. 2 of the liberals were out. The question was, can you sue high Bush administration officials for post-9/11 offenses? You know what the answer was. You don't have to read the opinion.
Do your editors show you any mercy in a situation like that? Do they say you can have a half an hour, or do you need to get something up on the internet right away anyhow? Bob?
No, I think, editors don't want to put something wrong up, and so they are quite good about that. And you just say, this one's going to take some time before I'm ready to write. And this also goes to, and it's kind of starting to sound like we're whining, but it is a difference with the way we have to operate now, because it used to be that we would all go up and listen to the announcement of the decisions. And when you're in the room and whoever wrote the opinion announces the outcome of it, you get a pretty good idea of the way it turned out. And so when you walk back downstairs and then get the actual opinion, you're reading it with some knowledge already of what this case turned out to be. We don't have that now, and that's what makes it a little harder.
So, Tony, go ahead.
Well, just one other thing is that when you speak about editors, one good thing about covering the Supreme Court is that our editors don't know that much about the court. Some editors, I should say, not all editors, but editors are expert on the White House. They're self-proclaimed experts on Congress, but they sort of defer a little bit to Supreme Court reporters.
Well, I agree with that, Tony. You've been campaigning for years for cameras in the court, and I always think, boy, that would ruin our lives. The editors would be watching and telling us, I heard that, so why don't we write this? Which is what they do with the White House, but they think the Supreme Court's entirely mysterious, and we wanted to keep it that way.
Another thing that's quite valuable is that the press corps is quite collegial. So we do put our heads together sometimes if there's a difficult point and try to figure it out together, and there's just a lot of brain power in the room.
So one thing I find is that members of the public are often quite surprised when I tell them that that I can't tell them what cases are going to be decided on Monday. How much advance notice do you have? What do you know that the tourist sitting in the gallery doesn't know at 10 o'clock on a decision day?
I mean, we're standing there. Some of us are in the courtroom. Some of us are in the press room. And the Chief Justice says, Justice Kagan has our opinion in Maslin Jack versus United States. And that's when we know that Maslin Jack is coming out that morning. I mean, unless it's the last day, you really don't know anything at all. And, it's always sort of entertaining when you get to June and you get these very well-sourced rumors. I remember being up all night trying to do my pre-write of Shelby County versus Holder because somebody had told us with great certainty that it was coming out the next day, and it didn't come out for another week and a half. So, yeah.
They do tell us ahead of time that there will be decisions. They do, for most of the term, signal whether there will be 4 or fewer or more than that. And then the other morning I was walking in past the bar line, and someone was going to be admitted to the Supreme Court bar. And he said, there are going to be 5 decisions today. I said, how do you know that? He said, they tell us. And he was right. Is that true? That they tell the people being admitted to the bar how many decisions there are going to be? Yes? This is news you can use.
Next time that happens, will you email me, please? I'll pass it on.
Someone said to me recently that they thought the highlight of the term this year really had to do with a cell phone. Was anyone in the court for that highlight? Tony, you're shaking your head.
Well, as Justice Breyer, when you go into the Supreme Court, no electronics are allowed, and as somebody mentioned, they're even inspecting. I have a Fitbit thing. They're worried that I might be able to broadcast something with my Fitbit, and so you have to strip down all electronics. But I guess justices don't get checked. So Justice Breyer had his phone, and it just started ringing in the middle of it, and he was very embarrassed.
I was not there, but I heard that after he finally realized it was him and fished it out of his pocket and turned it off, he buried his head in his hands.
He did.
And then at the
apparently the robes don't have pockets either, because it took him quite a while to get to it.
And then he was punching it and trying to turn it off.
He was on the bench at the Shakespeare Theater's mock trial a couple of weeks ago, and in the middle of the argument, his phone starts going off. Obviously a prearranged ploy, but he got a big laugh out of the audience. I think it was last term and not this term that there were several disruptions. Was there anything like that this term, or was it pretty quiet? So one thing that did happen. Right, I guess that's right. And
they'll be damned if they're going to protest before a 4-4 court.
Right. And there were no abortion cases. There were no big death penalty cases.
Well, they used to protest on the anniversary of Citizens United. Maybe that wasn't a sitting day or something.
Yeah. Maybe that's right. So one thing that happened only twice this term were oral dissents in the case against Ashcroft and Mueller that we mentioned a little while ago, and then on the last day, Justice Sotomayor dissented in the Trinity Lutheran case. How much of a highlight is that for the press corps? Is that a big deal, Joan?
Well, I love it. I think it gives us an insight into what matters to these individual justices. I remember being there when Justice Sotomayor dissented in the Schuette affirmative action case, related to affirmative action from Michigan State back in 2014. So it was exciting to hear her and to hear her say something big has happened here. Even though you have such a majority in this case, look at what's different. Look at how it's the first time that direct aid, financial aid could be going to a religious institution. So I think for those of us who are lucky enough to be in the courtroom, it's wonderful. But I also think for the folks downstairs who are keeping an ear cocked to the press office and hearing this, it also gives a sense of definition to what dissenters are thinking and what matters, because they only do it to get our attention, and it does get our attention.
It made me miss this term, Justice Scalia, because when he would do that, it would be very, you always knew you were going to hear something that you could use in your copy when Justice Scalia did that.
Does it change the way you report on a case?
I don't think it changes, other than stating the fact and that it means that someone felt very strongly about this. But I agree with Joan that it's definitely something that's lost when you're down in the press room because the atmospherics are just different. I was in the courtroom. I can't remember why. Rather than downstairs for the Schuette dissent as well. And I mean, it was really very, very telling because you had Justice Sotomayor reading and she's very grim-faced. And most of the justices look like they would rather be anywhere else than sitting at that bench today. But Justice Elena Kagan was recused from the case. And so she was like, hey, I'm happy to be here. This is not my problem.
Right. Oh, yeah, watching the body language is great because Justice Breyer starts in his oral dissent, and you can feel that some of them are thinking, "Oh, we'll settle in now for a while." You just and also not during Justice Breyer's this time or during Justice Sotomayor's, but sometimes you can catch a little bit of an eye roll, and you can catch a little bit of a get a load of him sort of gesture comments between individual justices that give you a bit of an insight.
It's also interesting that often the person reading the dissent is sitting next to the person who wrote the majority opinion. And Justice Alito, who we all know doesn't exactly have a poker face, I recall, I think it was the Hobby Lobby case where Justice Ginsburg read her dissent, and he did do the eye roll, which sort of caught everyone's attention at one of the things she said. And after that, they all became, I think, very good at looking straight ahead and not even noticing that something else is going on. Justice Kennedy's really good at that. He just looks straight ahead, and it's like he's not hearing it.
And of course, they're not reading their decision literally. They're summarizing it, and sometimes they're speaking extemporaneously, and sometimes they say things that are quite quotable, which really makes me miss going upstairs. In Parents Involved, I wasn't there for it, but as I recall, that's when Breyer said something like, never so few change so much law in a day or something like that. And then sometimes actually explained what the bottom line is. Was that something like that in the General Zone? I remember being upstairs for an EPA case, and it was very hard to know from the text how much the EPA had won or lost. But upstairs, after beating up on the EPA mercilessly, Justice Scalia, as an aside, says, and it's not in the opinion, let's face it, they won 97% of what they wanted. And it made it so much easier to go downstairs and write that.
Yeah, was that Rapanos?
No, I don't think it was.
I think that was Massachusetts against EPA, maybe.
I don't think it was that either.
No, it was
All
the
right.
one after.
All right.
There was also Justice Ginsburg did that for the ACA case, the first Obamacare case, in which the Chief Justice kind of took the four Solicitor General on a roller coaster ride about whether or not they were going to actually uphold this, and then there was a dissent, and then Justice Ginsburg read, and I have to say it was getting a little confusing by that point exactly what they had done, and she said the ACA emerges largely unscathed. And so we all said, oh, okay. Well, there's the bottom line.
We read with that.
And so that is, I think, a great advantage to be able to hear those kind of comments.
So in addition to covering their decisions, you report on oral arguments as well. Were there any arguments this term that you thought were especially noteworthy, any that maybe even changed the outcome of the case? Amy?
The one that I wrote about actually was a case involving a murder in the District of Columbia in the 1980s, and it was a fairly infamous murder of a mother of 6. She was brutally beaten and sodomized, and a group of men were convicted, and then after the fact, it turned out that the government had not provided their lawyers with a couple of pieces of evidence, some statements that might have helped to place the guilt onto someone else. And so they filed 2 cert petitions, and the Supreme Court granted the cert petitions and asked both sides to brief simply whether or not the convictions violated Brady versus Maryland, a very sort of straightforward, fact-bound question. And that just screams to me, were granting cert to overturn these convictions. And in the end, they didn't. And I think that in no small part it was because of the extraordinary oral argument by Michael Dreeben, the Deputy Solicitor General who handles a lot of the criminal cases. And there's a whole discussion about whether or not the Supreme Court bar is a good thing. And one of the things that I always point to is the Solicitor General's office, where they get these cases, usually at the merit stage, and you have someone like Michael Dreeben who just internalizes every aspect of the case. He was telling the justices what Chuck Brown's song was playing in the park when this murder was supposed to have occurred. And I think he was able to sort of pull all the facts together at that oral argument in a way that prompted the justices to say, no, this evidence was not actually material. It was really, if you have a chance to go listen to it on Oyez when it's, I think it'd be very useful.
I thought there was an interesting aspect of the oral arguments as well, which is that we often talk about the lack of diversity on the court and their past experiences. And in that oral argument, you heard the two former prosecutors, Alito and Sotomayor, who had been a district judge, Alito, who had been in courtroom. You could tell that they kind of got it in a way that some of the other justices didn't. And they were, would this have really worked with the jury? Even if you'd had this evidence, the other side would have still told the jury this. So I thought that they brought a very interesting kind of real world aspect to that oral argument that you don't always hear, and I thought was very interesting to listen to. I mean, that you're right. It was so interesting. It was like they became the jury in this murder case.
So one question I've asked in the last several years, and I can't quite ask it this year because the SCOTUSblog stat pack isn't out yet with average number of questions per argument, but it's been going up every year pretty much over the last 4 or 5 years that I've been looking, to the point where there are so many questions you can't imagine how there's any time to answer. So without the stat pack, is it your impression that receded this year? Has it been a little bit less impossible for a lawyer to answer a question than it has been in recent years? No opinions on that?
I don't think so.
No.
It seems to me and there were a couple of times this term where, especially on rebuttal, the lawyer didn't get a word out before there was a question from one of the justices. So no, I don't think it's changed at all.
And they all, when you ask these justices about why they ask so many questions, they're like alcoholics or something. They say, I know we do ask too many questions. We really need to stop, and then they just keep doing it. It's just a habit they can't break. I mean, obviously the purpose of the oral argument is for the justice. I mean, lawyers say we're happy when we get the questions because we want to know what the justices are concerned about or curious about. But to have the barrage of questions, I think it's just incredible. I don't know how they manage it. I think it's been a big part of why the specialized Supreme Court bar has evolved the way it is, because you really have to be, a superstar to be able to listen to questions from 4 different justices at once and then answer them in turn. And it's so I think that's when you need it, when you're going from the Matterhorn to Mount Everest, you need the best Sherpa in town, and so I think they've just created this atmosphere during oral argument that they just can't stop.
So Joan, I mentioned in the introductions that you're working on your next book, which is about Chief Justice Roberts. What can you tell us about that, if anything?
Well, it's exciting to be looking at a man who is difficult to understand and who has sort of acted in a kind of consistent way through most of his life that we've seen on the public stage, back to his Reagan years So I've spent a lot of time going back, tracing his family line back to England in the 1800s and looking at his roots and what he's all about in the past, but also trying to get a sense of how he deals with his colleagues today. So probably next year at this time I'll have more to say because I'm still doing the research and beginning the writing, but he's an intriguing subject. He looks like he might be just a more kind of a standard issue lawyer compared to my prior subjects of the first woman justice, the first Italian-American justice, and the first Hispanic justice, but he has his own intriguing story that's been fun to pursue.
Dahlia Lithwick wrote an interesting piece earlier this year criticizing in several ways how journalists covered the court, and she made one point I'd like to ask you about, which was about the lack of long-term follow-up on decisions. And let me give you some possible examples from this year. Will anyone put it on their calendar to do some reporting in 6 months or a year? Did Jay Lee, the immigrant from Korea who pleaded guilty to a drug crime that his lawyer falsely advised him would not lead to his deportation, will he get a new trial? Will he be convicted? Will he be acquitted? Will the government offer him a plea to a lesser offense that won't result in deportation? Or, for example, after the court ruled in the Bristol-Myers Squibb case that people from many states couldn't all sue them in California, will there be, suits in 20 other states filed? Will everyone sue them in Delaware or New York where they live? Will people just drop those lawsuits or settle them cheap? Is that something that you consider part of your beat and that you think your readers are interested in, or will you suggest those stories to others?
I think Dahlia is right that we don't do enough of that kind of follow-on, but I would distinguish between those two cases. Whether Jay Lee wins or not doesn't affect the legal principle the court announced. And it might be a curiosity about the particular facts of the case, but the court does two things at once, of course. It resolves a particular dispute, and it announces a broad legal principle. And really, if you wanted to do something on that first case, you'd look at the impact of that broad legal principle across a lot of cases. The Bristol-Myers case, in many ways much more significant and can affect lots and lots of different lawsuits, including the particular ones. And there, I really do think we should work harder to come back at what was the on-the-ground impact of these decisions.
I think Adam's right. I mean, to use a very law nerdy term, a lot of these cases are just the vehicle to get this legal issue up before the court. I think it would be interesting to do some follow-up, not sort of for the human interest stories or, what happened to Jay Lee, but because I think it sort of illustrates a broader principle, which is that people think of the Supreme Court as sort of the final arbiter of these disputes. And a lot of times, you can win the battle in the Supreme Court and lose the war the long term. The Supreme Court had a case that it decided last week, Maslin Jack versus United States, and the question was whether if you lie to immigration officials, can they take your citizenship away? The government had argued anytime you lie, no matter how trivial, they can take your citizenship away, and the court disagreed with that. They said it has to be something that would matter. And so this is a victory for Chris Landau, who argued the case in the Supreme Court. She is almost certainly going to lose, because I do think that immigration officials are going to care in her case that her husband was a member of the Bosnian Serb Army Brigade that participated in the Srebrenica massacre. And there are so many stories like this where you win the battle and lose the war.
We've got about 10 minutes to go. I'm going to ask another question, but after that, I'll ask for questions from the floor. And I think we have a mic that will be passed around. Is that right? So if you've got a question, I have it. Here we go. Someone will get it from me. And so if you have a question, you can wave your hand and she'll bring you the mic. So let me just ask about the Solicitor General's office. They participate in many more cases in the court than anyone else representing the United States, and this has been a year of great change there. Don Varelli retired last June after 5 years. His deputy, Ian Gershengorn, was acting through Inauguration Day, and since then we've had two different acting Solicitor Generals. Has that made a difference that you can see in the operations of the court, in the in the quality of the government's presentation? Has it made any difference to your reporting? Do you get to know the SGs at all and talk to them about what's going on? David, way down at the end, have you got anything on that?
You said, has it made a difference from what we can see? And the answer is no. I can't see any difference. Jeff Wall's quite capable. He filed all the briefs in the travel ban case. Nice guy, smart lawyer. And I suppose he sort of won in the end. But it seems like the office is doing fine. But you remember, this happened also late in the year. I mean, most of the cases that were up were already set and ready to go. So I think we'll have a better sense of that next year.
What's changed, I would say, is that the Trump administration has taken different positions. So, for instance, the transgender student case went away because the administration withdrew the guidance that basically that case had been built upon, and so it starts over again. So that's where you've seen the difference.
There was another case in which the court had granted cert. The National Labor Relations Board was the petitioner in one case, and then there were two other similar cases presenting the same issue, and the court granted all three. The court granted cert after the government had filed its cert petition, but before the switch in administrations. And you could kind of see that maybe even the court thought that perhaps the government might switch sides, which it did when it filed a brief supporting the employers when it had previously supported the employees in the case.
But to their credit, it looks like the NLRB will file its own brief on the other side, so the government looks like it's going to be on both sides of that
Yeah,
case.
it's going to be great. I can't wait.
Do we have any questions on the floor? Okay, starting over there.
Hi. I'm a law student who has a journalism degree, so I think that what you all do is great, so thanks for coming. For my question, there's recently been tension between the media and the executive branch. I was wondering if the effects of any of that tension has trickled down into the judicial branch relationship with the press, and could that perhaps have had anything to do with Chief Justice Roberts paying tribute to Lyle Denniston?
I think the answer is no, isn't it? I mean, I think the court sort of separates itself from the executive branch, and nothing has changed on our front as far as our dealings with the press office that I'm aware of. Isn't that right?
Yeah, I think there's not much of a relationship to start with, so it hasn't really changed. We don't, it's the beat where we rarely get to talk to the people we cover. Fred Graham used to cover the court for CBS. Used to say only the Vatican and the CIA are more secretive than the Supreme Court, and of course now the Pope tweets and the CIA has a YouTube
CIA
channel.
leaks, right.
So and the Supreme Court has none of that. So I mean we have I think a cordial relationship with the justices. The Chief Justice has us in for lunch once a year, which is an improvement because under Rehnquist it was once every 2 years. And but I think there's just we don't really get to have much of a relationship with the justices.
I mean, I think to give credit where credit is due, under the Roberts Court, there were some changes that did make it a little bit easier for us to do our jobs. It used to be that the Supreme Court would release orders and opinions at 10 o'clock and start oral arguments at 10 o'clock, and now the orders come out at 9:30 to give you a chance to write about the orders before you have to go upstairs for the oral arguments.
And we get transcripts very promptly, which is good, because all of these questions give rise to a lot of crosstalk, and getting a transcript within hours is a huge, huge benefit.
Yeah, but where we've stepped back is under the Roberts Court is the release of audio. We used to be able every once in a while to get same-day audio, which I think was so important, and that hasn't occurred. We've asked, and that hasn't happened lately.
Sir?
I'd like to ask Val to do a little tea leaf reading on the political gerrymandering case the court's going to hear next term. They've been avoiding this kind of case for years, mostly on the argument that it was not justiciable and there was no way to really decide it. So I at least have trouble thinking that they've decided to accept it now just to say that again. So I'm sort of curious what any of you think about how the decision was made to accept the grant cert in it. And
so an important point is that it didn't come up on the cert docket. It came up on the court's mandatory appellate docket. So my initial impulse would be to read something into this also, but this is one of those cases which they have a very hard time turning down, and even the mode in which they took it was to what? Jurisdiction postponed. So even now they may find a way out of it. And then the second set of tea leaves is that there was a stay granted almost immediately after they decided to hear the case, and that was 5-4 with the liberals in dissent. So that, this whole case turns on Kennedy, and assuming the stay tells you something, it tells you that Kennedy's not ready.
Someone else? There you go.
That's on the justices' writing styles. Are there any particular justices' opinions that you find easier to summarize or easier to follow, or does it vary more case by case and maybe clerk by clerk?
Don't we sort of roughly agree on this one that John Roberts and Elena Kagan are terrific? Gorsuch is a very good writer, but he's a terrific writer, actually. But the three of them are really good. I'm not much of a fan of any of the others. What do the rest of you think?
Well, I think that some of them write for different audiences. So I think that some of the justices who are, especially in majority opinions, are writing for lawyers. And I think some of them aren't. The Chief Justice has talked about he tries to write for his sisters, who he thinks are very smart but are not lawyers, and that he would like them to understand what he does. I've heard Justice Sotomayor say that this is something that she's writing for lawyers and judges to make sense of what they're supposed to do next. They're all, I think, good writers in dissent, because there they can sort of write whatever they want to and not have to worry about everybody else. And I think all of them write good dissents.
We've got time for one more, probably. Okay.
Hi. I have a question about the case with the band, the slants. It has some very kind of controversial implications regarding free speech, and I want to know, as journalists, kind of what's your read on that?
Is anybody thinking of trademarking a derogatory term?
It was yet another decision from the Roberts Court, and it's issued quite a few of them, in which it proved to be a very strong First Amendment free expression court, willing to protect even offensive, hateful speech.
All right. I think on that note, one more. Okay. Great.
Hello, everyone. So my question is about, there was a case that I don't think has really received a lot of press, which is the victory in the birth certificate case, where same-sex couples are both allowed to be on the birth certificate. And we all know that the court just decided to take the case about the bakers. And given what's been said earlier about Gorsuch's kind of being a staunch protector of religious freedom, I was curious as to your read and how that might work out.
So you're talking about this Masterpiece Cake Shop, which is the case of a Colorado man who has a bakery and says that it would violate his religious beliefs to create cakes for a same-sex marriage celebration. And the Supreme Court had a couple of years ago a very similar case up before it on cert involving a wedding photographer in New Mexico, and it pretty quickly denied review in that case. And so we were all trying to figure out what the heck was going on as this case sat on the Supreme Court's docket for weeks and then months. I think many of us thought that perhaps someone was writing a dissent from the denial of review. And the only thing that's changed, as far as I can tell, is that Justice Gorsuch has replaced Justice Scalia. So I don't know. I mean, I think that suggests that maybe they think now there are 5 votes.
I'd like to offer the profound insight that it depends on Justice Kennedy.
And Justice Kennedy does not want to break his record of being the champion of same-sex anti-discrimination laws. So I know how it's going to come out.
He is a fan of religious liberty. I mean, he was in the majority in the Hobby Lobby case, which is a religious exemption case. So I think it's actually a little bit of a tough call for Kennedy.
I thought it was interesting, too, in the reaction to that. I don't know if others noticed that the quotes from the lawyers who had brought this case was all about his artistic belief and his artistic talent. And at least when this case was finally granted, seemed to downplay the religious aspect of it, which I thought was interesting for them.
So the metaphorical clock has now struck 2, and we are turning into a pumpkin. Thank you all very much for coming, and see you next year.